From the opinion pages of the Wall Street Journal, this is Potomac Watch.
After an unsuccessful appeal to the Supreme Court this week, President-elect Donald Trump is sentenced in the New York hush money criminal case, but with no penalty for his conviction last year on 34 felonies, and with his appeals now about to begin. Welcome, I'm Kyle Peterson with the Wall Street Journal. We're joined today by my colleagues, columnist Bill McGurn and editorial board member Colin Levy. The word unprecedented has gotten a workout in the Trump years, but no stopping now, as the president-elect of the United States on Friday, 10 days before his second inauguration, was made to dial into a sentencing hearing in New York State. This was the criminal case brought by Manhattan District Attorney Alvin Bragg, accusing Trump of falsifying business records in the run-up to the 2016 election with respect to the hush money payment to Stormy Daniels. The jury last May found Trump guilty, but sentencing was put on hold after a U.S. Supreme Court ruling on presidential immunity. Then it was put on hold so as not to affect or be seen to affect the presidential election. Last year's trial was not streamed, but the 30-minute sentencing hearing on Friday was, so this might be the first time listeners have gotten a chance to hear at least two of these voices. Let's start with the prosecution, which went first. This is Joshua Steinglass, Manhattan Assistant District Attorney.
In finding the defendant guilty in this case, the jury necessarily found unanimously that the defendant falsified 34 separate entries in his business records with the intent to defraud, which included an intent to commit or conceal a conspiracy to promote his own election by unlawful means. Having presided over the trial, Your Honor is very familiar with the conduct, its seriousness, and the overwhelming evidence to support the jury's verdict. I'm certainly not going to rehash that now.
Then went the defense, and here is President-elect Trump getting his chance to say his piece.
I just want to say I think it's an embarrassment to New York, and New York has a lot of problems, but this is a great embarrassment. I believe that this and other cases that were brought, as you know, the DOJ is very much involved in this case. It's because that's the political opponent they're talking about. The DOJ is very involved. You have a gentleman sitting right there from the DOJ who was from the DOJ's office. He was also involved with the New York State Attorney General's case. And he went from there to here. He went around and did what he had to do. He got them to move on me. But in the meantime, I won the election in a massive landslide. And the people of this country understand what's gone on. This has been a weaponization of government. They call it lawfare. Never happened to any extent like this, but never happened in our country before. And I'd just like to explain that I was treated very, very unfairly. And I thank you very much.
And finally, here's New York State Judge Juan Merchan explaining his sentence of unconditional discharge, which essentially means no penalty, as the only lawful option available to him.
The protections afforded the office of the president are not a mitigating factor. They do not reduce the seriousness of the crime or justify its commission in any way. The protections are, however, a legal mandate. To be sure, it is the legal protections afforded to the office of the President of the United States that are extraordinary, not the occupant of the office. This court has determined that the only lawful sentence that permits entry of a judgment of conviction without encroaching upon the highest office in the land is an unconditional discharge. At this time, I impose that sentence to cover all 34 counts. Sir, I wish you Godspeed as you assume your second term in office.
Bill, what do you make of this as the final resolution to this criminal case brought by Manhattan District Attorney Alvin Bragg?
Well, first I would say I don't think it's final. Trump now has the possibility of appeal. I think he has a good case. Of all the cases brought against him, I think this is arguably the flimsiest, and it involves some really questionable rulings by the judge, beginning with allowing this one misdemeanor account that was expired because of statute of limitations and elevating that into 34 felony counts. It's all symbolism. Someone on TV described it as a thrill kill. When the lawfare first started, the idea was to prevent Trump from getting back in office. That failed. It's a last little bit tweak of him before he goes in. But I think it's going to be be forgotten pretty soon. The appeals will wind their way through New York courts, take a while, and no one will pay attention till it comes down at the end. But I think the advent of a Trump administration is going to render all this moot.
Hang tight. We'll be right back in a moment. Welcome back. This can't have been what Manhattan District Attorney Alvin Bragg was thinking, imagining would happen when he brought this case originally 2 years ago, Colin. What narrowed the options here was Trump's remarkable political comeback, including his victory in the November election. Think about what else was floated to the judge. One idea was holding sentence in abeyance, suspending the sentencing of this case until Trump left office, meaning that you could have 4 years of a second Trump administration. He would leave office in 2029, and then New York State would order him to come be sentenced in this case and potentially go from the White House to jail after the fact. That doesn't seem like it would be in the interest of the country. Another thing that was floated to the court was preserving the jury verdict but terminating the proceedings. This is from an order by Judge Merchan. He said that he refused that idea because that would deny Trump the ability to appeal the verdict, the appellate rights that he has that are part of American due process. And so it is remarkable to think that the judge, as you heard him in that clip, he says that the immunity that the president has and that Trump is going to gain in 10 days when he takes office, it does not diminish what the jury said in its verdict. But he seems to think that there were no other options available to the court.
I mean, I think in some ways he's probably right there. I mean, as for the sentencing, it's certainly fair to say that it's better than the alternative. Anything else that the court would have done, any kind of conditional discharge, really would have interfered with Trump's official obligations as the incoming president, not to mention it would have been just a huge mess. So the prosecutor did acknowledge, I think, when he was talking that it was necessary to be respectful to the office of the presidency. But there was also just an enormous amount, I thought, of bitterness in the prosecutor's statement, which, as you noted, we did for the first time get to actually listen to these proceedings. So that was notable to me as he sort of went on about how, instead of preserving and protecting and defending our established system of criminal justice, the once and future president of the United States has engaged in a coordinated campaign to undermine its legitimacy. I mean, that's just, that's sort of high dudgeon there. And all of this proceeding in the context of what you said earlier, which is that, the key thing to remember here is that this case never should have been brought. You don't have to be a Trump fan to understand and know instinctively that this case was legally problematic on many levels. When you get past all the salacious detail and the unfortunate behavior, it was a paperwork case at its core, right? He was being prosecuted for whether or not he kept the right paperwork, whether or not it was accurate. And on top of that, as I'm sure we can talk about later, the issue of whether or not New York State had any business wading into the federal election law charges that they were using as the premise beneath all of this. So it couldn't have turned out, I suppose, any other way than it did today, at least in terms of the sentencing.
Let me put a pin in that point for a second, because the other fascinating part of this story this week has been Trump's appeals up the chain of the state courts and then the federal courts trying to halt, to block this Friday sentencing hearing. Earlier this week, he went to the U.S. Supreme Court and he asked the justices there to stop Judge Merchan's sentencing hearing from taking place. He had a couple of arguments. One is whether a sitting president's complete immunity from criminal prosecution extends to the president-elect of the United States during the brief but crucial period between his election, his certification as the president-elect, and his inauguration. So, Bill, the argument there is that the president has immunity from prosecution, and President Trump is about to be the president. He's already deep into the transition weeds. He's not the president yet, but he will be soon. I don't know. It would be fascinating to see the justices take that up on the merits, but that does seem to conflict with the unitary executive theory that we only have one president at a time.
Yeah, and I think that's reflected indirectly in the Supreme Court's order refusing to postpone the sentencing. The problem is this is all unprecedented. We've never had this come up before. So I think you can make arguments on either side. It's notable to me, there were 4 justices who wanted to buy Donald Trump's argument and postpone sentences. But Amy Coney Barrett, for example, sided with the people that said no, and the majority, John Roberts and everything, that kept it in place. I think that's, again, it's not clear what is the proper one. What surprised me most about this is not that they split this way, but that Donald Trump was pretty benign about the court's decision. I think he hailed it as a good decision because it basically kicked the ball, right? It just said, we're not going to intervene on this. And, this part of me, my instinct is that it's better for the court not to always be jumping in and resolving our political issues. So, we're going to know a lot more when the case works its way through appeal. But I was just struck that Trump did not attack and even praise the decision by the Supreme Court.
The other argument that Trump's legal team made to the Supreme Court is that after the Supreme Court's ruling on presidential immunity last summer, some of what took place at his trial was improper. So he says that testimony introduced at his trial about official presidential acts, some of his White House aides were called to testify, and he's saying that that is enough to throw out the entire case. Judge Merchan has ruled on that. In his view, the testimony by those White House aides involved only unofficial conduct by President Trump, not official conduct that would implicate presidential immunity. He also says that in his view, the evidence was overwhelming enough of Trump's guilt that even if you assume that what Hope Hicks and so forth said at trial was concerning official conduct and you excluded that, that is not enough to knock out the jury verdict. So that is one of the questions that presumably President Trump's team will mount on appeal. Their argument to the Supreme Court was that immunity is an appeal that takes place and pauses the criminal proceeding. And so that should be enough to halt the sentencing order. As Bill says, the Supreme Court split 5-4 on that, denying any stay to President Trump. 4 justices, Justice Clarence Thomas, Justice Samuel Alito, Justice Neil Gorsuch, and Justice Brett Kavanaugh said they would grant the application, but they did not explain exactly why. So we have to read somewhat in between the lines. The majority has an unsigned statement, says that these alleged evidentiary violations trial can be addressed in the ordinary course on appeal. It also says that the burden that sentencing will impose on the president-elect's responsibilities is relatively insubstantial in light of the trial court's stated intent to impose a sentence of unconditional discharge, unquote. And so, Colin, I read that as the majority of the Supreme Court looking at this and seeing the same problem that Justice Merchan was seeing, which is that New York was not going to be excited to set aside this unanimous jury verdict, yet there seems to be no substantive penalty that can be put on the president who's coming into office in 10 days. And it doesn't seem like it was in anyone's interest for this to be hanging out there in limbo without any final resolution at the trial court level, because one thing that's important to know is Trump's appeals up the chain here could not start until the sentencing had been finished.
No, that's right, Kyle. And I mean, look, I think, frankly, the justices probably don't want to have to deal with some of this, but they probably will have to. I mean, I think on the merits, there are some serious questions that do need to be addressed just so this sort of thing doesn't continue to go on, this kind of weaponization doesn't continue to go on. But I wanted to bring up something else that Bill mentioned that I think is important to talk about here regarding that split on the court in which Amy Coney Barrett and Justice John Roberts sided with a more liberal side of the court. And as a result, there was just an enormous outpouring of fury on the right among MAGA folks against Amy Coney Barrett. And, that's something that I think it's a really disturbing development. The targeting of her as though her only duty there as a justice on the Supreme Court who was appointed by Donald Trump was to pass some sort of loyalty test in terms of the way she resolves her decisions. I thought that was disturbing. It's exactly what we've often written about regarding the way that the left approaches the court and the insistence that the justices toe a political line, and this increasing interest in only looking at Supreme Court justices as some sort of an extension of the political sphere. So I just wanted to mention that. I think it's a really dangerous precedent to set here to say, among conservatives that if there are differences of opinion, that those are somehow malicious, malign, shouldn't be tolerated. I don't think that the right wants to go the same way the left has gone on the court.